Court calls case, People versus Kevin Kernan.
Before we even hear the first name called, understand what kind of courtroom this is. This is not a single dramatic trial. This is a fast-moving docket where dozens of lives rotate through in minutes. Some people walk out relieved. Others leave with warrants, debt, or restrictions that can follow them for years. And in this courtroom, presided over by Judge Simpson, efficiency is the rule. But make no mistake, accountability is the theme. What you're about to see is a snapshot of real justice in motion. Plea deals negotiated on the fly, defendants missing court and triggering immediate bench warrants, and moments where one sentence from a judge changes someone's entire situation. Some cases are minor civil infractions. Others carry jail exposure, loss of rights, or long-term consequences. Watch closely how differently people are treated based on preparation, presence, and honesty. Notice how often failure to appear becomes the turning point, and pay attention to how quickly things escalate when someone doesn't show respect for the process. As we move through this docket, ask yourself, if you were standing there, would you be ready? Would you know what to say or what not to say? Because in this courtroom, seconds matter, words matter, and silence can be costly.
Conrad Silver on behalf of Pittsfield Township.
And good morning, Your Honor. Joseph Hall appearing for on behalf of Mr. Kieran, who is approaching. And Kevin, if you could state your name for the record, please.
Kevin Kieran. Thank you.
You have an agreement, Your Honor. On that count 2 of civil parking. Defendant's going to admit responsibility to that count 2. If you accept it, it moves Mr. Embry.
That's a correct statement, Your Honor. I have authority from the client to admit responsibility on his behalf, and I do so for Your Honor's purposes.
All right, court will accept that admission. To count 2, count 1 is dismissed. Fines and cost of $180. When can that be paid?
Your Honor, can we get 14 days to pay, please? I said please.
You got $180.
I said please,
No,
Judge.
Pay it by June 6th.
Thank you very much, Your Honor.
Thank you. Thank you, folks.
Take care. Yep.
Court calls the case of the People versus Jessica Fox.
Tasha Beavers for the People. Good morning, or good afternoon, Assistant Public Defender Lauren Kearney on behalf of Ms. Fox. Ms. Fox, please state your name for the record.
Okay, I think I got it.
Okay, your name?
Jessica Fox.
All right, very good. All right.
Your Honor, I did, just last night, Ms. Fox did get proof of her treatment and, tests for the last, from July to December of last year. I did confirm that she was negative for alcohol in all of the tests, and she did complete, treatment for quite some time. I think she started back in, 2021 and then completed in 2024. I can provide that to the court if the court would like that. Given the nature that I just did get that to the people last night, I am requesting an adjournment for further plea negotiations, and hopefully that can assist us in coming to a resolution.
This is a very different kind of courtroom moment, and one many people misunderstand. Jessica Fox's case isn't about punishment today, it's about documentation. Her attorney brings proof of treatment, proof of testing, and proof of compliance, but timing matters. The court isn't rejecting her progress, it's acknowledging it, while still respecting procedure, because evidence delivered late still needs review. That's why Judge Simpson grants an adjournment instead of rushing a resolution. This is how rehabilitation intersects with law. Treatment completion doesn't erase a charge automatically. It strengthens negotiating power. And you can hear it in the tone. No hostility, no warning, just structure. Ask yourself this: should courts move faster when defendants show proof of self-improvement? Or is slowing down the safest way to ensure fairness? This moment reminds us that justice isn't always loud. Sometimes it's quiet, procedural, and deliberate, but still impactful.
June 18th, 2025, 9 a.m. Bond will continue.
Thank you, Your Honor.
All righty. Thank you, Ms. Fox.
Thank you.
Court does call the case People versus Frean Haywood.
Tasha Beavers for the People.
I'm sorry.
This is a show cause for them to
So show cause has already been issued. Frean Haywood, no response, bench warrant, 5,000. 10%, that warrant will issue immediately. Court calls case People versus Christopher Holt.
Ashley Lonnie for the People. Good afternoon, Assistant Public Defender Lauren Kearney on behalf of Mr. Holt.
Yeah, good morning. This is Christopher Holt.
All right, thank you.
So, Your Honor, I apologize. I'm asking for one last adjournment. Mr. Holt and I did speak about the offer. I think we're getting very close. We just need to finalize some details.
All right. June 4th, 2025, 9 a.m. Bond continue. All right, thank you, Mr. Holt.
Thank you, Your Honor.
Court calls the case, People versus Micah Jones.
Echelon of the people. Good afternoon, Assistant Public Defender Lauren Perry on behalf of Mr. Jones. Your Honor, I attempted multiple times to contact Mr. Jones. I was not successful. I don't see him here in the courtroom. Not sure if he's on Zoom. I don't have an explanation for his failure to appear, and for the record, I would request an adjournment.
I got two screens, so I don't.
He's not.
You don't have it. All right. Jones, Micah Jones, no response. Bench warrant will issue for defendant's failure to appear. Bond will be set in the amount of $5,000. Up to a 10% privilege. That warrant will issue immediately.
Here's where patterns start forming. Another failure to appear. Another bench warrant. Enter another $5,000 bond with 10% privilege. And notice how quickly Judge Simpson moves. Because by now, this isn't surprising. It's procedural. From a legal standpoint, the judge has no discretion here. If the defendant isn't present and there's no valid explanation, the warrant is automatic. The court must protect its authority. But from a human standpoint, this is where lives get complicated. Arrests lead to job loss, childcare issues, and cascading legal trouble, all because of one missed appearance. Ask yourself, should courts offer more flexibility for missed appearances, or does that weaken accountability? This is the invisible weight of the system, quiet, fast, and relentless.
Court does call the case of the People versus Pauline Macharia.
Echelon of the people. Assistant Public Defender Annalie Burgess, on behalf of Ms. Macharia, who should be assumed.
Yes.
Please unmute and state your name for the court.
Pauline Macharia.
Thank you.
Thank you, Your Honor. I'm respectfully requesting an adjournment. I have discussed this matter both with the people and my client. I believe this is a case that will ultimately be able to be resolved, but we just need to speak about a few more things before that happens. I agree, Your Honor.
June 18th, 2025, 9 a.m. Bond continued.
Thank you, Your Honor. Thank you.
Thank you.
Thank you.
Thank you, ma'am. Court calls the case, People versus Rebecca Miller.
Echelon for the people. Assistant Public Defender Annalie Burgess, and on behalf of Ms. Miller, who appears via Zoom from Dawn Farm. Ma'am, can you please unmute and state your name for the court?
Okay, I got it. Thank you, Jonathan. Sorry, I was
All
like,
right.
I wasn't unmuting.
Your name?
Rebecca Miller.
Thank you.
Thank you, Your Honor. So the people have extended an offer in this case that I was able to briefly discuss with my client yesterday. However, she is inpatient at Dawn Farm. We were just able to connect for a phone conversation last night. So I'd be requesting an adjournment to further discuss that with her. And then if she would like to accept that offer, is the proper case for the court.
This case highlights something important. Access matters. Rebecca Miller is appearing from a treatment facility, and communication has been limited. The court recognizes that reality, but still requires structure. An adjournment here isn't favoritism, it's practicality. The judge balances fairness with order, allowing time for counsel-client discussion while keeping the case moving forward. This is the system functioning as intended, neither rushed nor indulgent. Audience question: do you think remote appearances from treatment facilities should carry more flexibility than standard cases? Moments like this show that justice isn't just about guilt, it's about logistics, access, and context.
Adjourned to matter June 4th, 2025, 9 a.m. Bond continued. All right. Thank you, Ms. Miller.
Thank you, sir.
Court calls the case, People versus Kiana Patterson.
Echelon for the people. Assistant Public Defender Annalie Burgess, on behalf of Ms. Patterson, who may be present via Zoom.
I'm down to one screen. Patterson, I don't have one.
Your Honor, I don't have an explanation for Ms. Patterson's failure to appear. I did leave her a voicemail, but unfortunately did not hear back. For the record, I request an adjournment.
Bench warrant will issue for defendant's failure to appear. Bond will be set in the amount of $5,000. Give a 10% privilege on that. That warrant will issue immediately. Court calls the case of the People versus Jada Taylor.
Echelon for the people.
Good afternoon, Assistant Public Defender Lauren Perry on behalf of Ms. Taylor. Ms. Taylor, please unmute and state your name for the record.
Hi,
Oh,
Jennifer.
We're asking us this for final settlement conference.
Jury final settlement conference, June 6, 2025, 9 a.m. jury selection, June 9th, 2025, 8:30. Both of those proceedings are in person.
This is a pivotal shift. When jury dates are set, the case becomes real, fast. This isn't negotiation territory anymore. This is trial preparation. By scheduling both the final settlement conference and jury selection, the court is applying pressure. Either resolve the case or prepare to present it to 12 strangers. From a legal strategy standpoint, this is where cases often settle. Nobody wants the uncertainty of a jury, especially for misdemeanor-level exposure. Ask yourself, if you were a defendant, would you gamble on a jury or take a deal? This moment signals seriousness. Once juries enter the picture, everything changes.
Thank you, Your Honor.
Thank you.
Thank
All
you.
right, thank you, ma'am. Court calls the case of the people versus David Wagner.
That's the people.
David oh, there he is. Okay. I kept looking at my screen and didn't realize there were actual people here. No. Your name, sir?
David Charles Wagner Jr.
All right. Sir, this is all right. You are before the court on a misdemeanor complaint that alleges that on or about September 26, 2024, at the location of 2224 Gulfside Road in Pittsfield Township, Washtenaw County, State of Michigan, that you did fail to provide proper care and or work beat 2 or 3 animals, contrary to Michigan statutes. That's an abandonment or cruelty of animals statute. You understand what you're charged with, sir?
Yes, sir.
All right. That's a misdemeanor punishable by up to 1 year incarceration, a $2,000 fine plus court costs. Court could order community service also, or any combination of those penalties. You understand that?
Yes, sir.
You also understand that the court could order a psychiatric evaluation and may order cost of care of housing any animals that were seized, as well as either housing costs or veterinary costs. You understand that?
Yes, sir.
And I also could order that you not possess or own any animals. You understand that?
Yes, sir.
All right. First question I have for you is, do you wish to be represented by an attorney?
Yes.
This is a public defender case.
Assistant Public Defender Annalie Burgess with and on behalf of Mr. Wagner, we would waive any further reading, stand mute, and ask for an adjourned pretrial date, please.
Defendant every way from a reading standing mute. Court will enter a not guilty plea in this case. Pretrial in this matter will be adjourned June 4th, 2025, 9 a.m. As to bond.
Your Honor, the people do request standard bond conditions and an unsecured appearance bond. And we also are going to make a request that while on bond, the defendant have no animals in his ownership or custody or control.
Not in my name. Yes. I have 4 cats and two dogs. They belong to my wife, my kids.
Anything you want to say, Ms. Payne?
Just briefly, Your Honor, I would ask that those animals be allowed to stay in the home. He states they belong to his wife and children, understanding that my client should not have any interaction with those animals, so to speak. I would ask that he be allowed to remain in the home, certainly, and ask that the pets not be removed from his wife and kids.
You said there were how many cats?
4.
And 2 dogs?
Yes, sir.
What kind of dogs?
One is it's a small dog. That is my wife's dog. It's a poodle, Yorkie poodle. That's my wife. Is my.
Okay. What kind is the other dog?
Um.
All right. Here's what I'm going to do. Going to set his bond at a $10,000 personal recognizance bond. I'll order standard conditions, including no assault to behavior or possession of any weapons, no alcohol, recreational marijuana, or any illegal drug use. I'm going to indicate the defendant is not to have contact with or have possession of any animals.
Yes, sir, I understand.
This is one of the most consequential rulings in the entire docket. Judge Simpson isn't just setting bond, he's imposing behavioral restrictions that directly affect daily life. Animal cruelty charges carry unique authority. The court can restrict ownership, demand documentation, and even remove animals from a household, regardless of who claims ownership. The judge is clear. prove the animals belong to someone else or they're gone. This isn't symbolic, it's enforceable. Audience question: should courts have this level of authority over household property when animal welfare is involved? This moment shows how criminal charges can reach far beyond fines or jail, into homes, families, and responsibilities.
So I'm going to indicate that with reference to the 4 cats and 2 dogs, I would need either veterinary paperwork or others types of purchase paperwork that would indicate by the next hearing, that would indicate that these animals have ownership with someone else other than defendant.
Yes, Your Honor.
Yes.
Otherwise, so that we're clear. If I don't get that, then what's going to end up happening is I'm going to order all of them removed from the home. All right.
Understood.
All right. Thank you.
Thank you. We'll get this number to you.
Yeah, that was 6-4 or 6-18, I'm sorry.
6-4.
Thank you.
Court does call the case People versus Klaya Williams.
Ashley, one of the people? This is a show cause for people to appear for.
It's a show cause.
Yes.
It is. Klaya Williams. No response. Bench warrant will issue for defendant's failure to appear. Bond will be set in the amount of $5,000. I'll give it 10% privilege. That warrant will issue immediately. Court does call the case of the People versus Monai Williams.
Ashley, one for the people?
This is an arraignment.
Yes, sir.
Monai Williams. I'll issue an order to show cause on this.
Thank you, Your Honor.
Court does call the case People versus Sammy Alderson.
Conrad Silver on behalf of District Township.
Assistant Public Defender Annalie Burgess on behalf of Mr. Alderson, who gave the authority to accept the offer on his behalf.
So Your Honor, I move to add count 2 of double parking. Defense counsel is going to admit responsibility if you accept it and move to dismiss to reading third.
And you have authority to accept that,
Yes, Your Honor.
and on behalf of your client, do so.
I do so, yes. Your Honor.
Okay. Court will accept that admission to count 2. Count 1 is dismissed. Fines and costs of $180. When can they get that paid?
To be candid, Your Honor, I did have a long conversation with Mr. Alderson. He receives SSI and was just asking if the court would give him as long as possible to pay. So I told him that.
Do we know how much the SSI is?
I don't know exactly, or I should say I did not write down how much he gets monthly, Your Honor. He did say that he knows for a fact he could pay it within 6 months or by the end of the year.
This exchange highlights how judges weigh financial reality against accountability. Sammy Alderson isn't disputing responsibility. He's explaining capacity. SSI income changes the equation, but it doesn't erase obligation. And Judge Simpson's response is measured. Not 6 months, not immediate, 3 months. That's the balance courts aim for. Too lenient and fines lose meaning. Too strict and compliance becomes impossible. By setting a clear deadline, the judge creates structure without trapping the defendant. Notice what doesn't happen here. There's no interrogation, no lecture, because the defendant communicated through counsel, acknowledged responsibility, and showed intent to pay. Audience question: should courts calculate fines based on income, or should penalties stay flat to maintain equality under the law? This is quiet justice, firm, fair, and procedural. And it works because both sides respect the process.
So I said I would explain to Your Honor the situation after.
Yeah, without knowing what his SSI is. So here's what I'll do. I'll indicate that he needs to pay that by July 31st. Okay, so that'd be 3 months. That'd give 3 months if.
Your Honor.
Okay. Court does call the case People versus Audrey Bey.
Conrad Silver on behalf of District Township.
Chief cases.
I'm here, Your Honor.
Good afternoon, this is the Public Defender Lauren Perry on behalf of Ms. Beatty. Ms. Beatty, please state your name for the record.
Audrey Bey.
All right.
So, Your Honor, we have come to resolution. Ms. Beatty got her permits. She passed her driving test on Monday. I did provide that to Ms. Taylor. I hope. I did email it over yesterday.
You got her permit when?
She passed the test on Monday.
And I do have a copy of it, Your Honor.
You did. Okay.
I do. So In case 1391, she's going to admit double parking.
Okay.
So I have that count to double parking in 1391. If you accept that admission, move to dismiss the original misdemeanor as well as case 1392.
Correct, counsel?
That is correct, Your Honor. I actually would like to accept that offer today.
All right. And Ms. Beatty?
Yes, Your Honor.
All right, do you admit responsibility to the fact that on August 10th, oh my goodness, 2016, at a location of Michigan Avenue in Pittsfield Township, Washington County, State of Michigan, that you double parked a motor vehicle?
Yes, Your Honor.
All right, court will accept that admission to count two. Count one is dismissed, and that's in the case ending in 1391.
This is textbook resolution. Audrey Bey did the work, passed her driving test, obtained permits, provided documentation, and the court responds accordingly. 2 cases dismissed. 1 civil infraction remains. Fine imposed. Deadline set. What stands out here is Judge Simpson's tone. Calm, direct, almost conversational. That doesn't happen by accident. Prepared defendants receive efficient outcomes, and listen carefully to how the judge confirms details, dates, locations, facts. This isn't casual. Every admission must be precise because it becomes part of the record. Audience question: should past compliance erase older violations, or should history always follow a defendant? This moment reinforces a key lesson. Progress matters, but it must be proven. When it is, the system can close the book cleanly.
And also, case ending in 1392 is dismissed on the prosecutor's motion. Fines and costs of $180. When can you get that paid, ma'am?
By Friday, Your Honor. This Friday, Your Honor.
This Friday?
This upcoming
Okay.
Friday.
It's 16? No, 23. Working on Alan's calendar. I know. I resisted, but now it's all on. All right, pay it. Ma'am, pay it by the 23rd, okay?
Yes, Your Honor.
Actually, no, here's what I'm gonna do, ma'am. Pay it by the 27th. I'll give you till after the holiday. Okay,
Thank you, Your Honor.
thank you. All right,
Thank
you
you.
have a great day.
You have a better one. Thank you.
Court does call the case of the people versus Tasha Beavers.
Lorenzo on behalf of Pittsfield Township.
This is annoying. Oh, hello.
Hello,
What's your name?
Tasha Beavers.
All right. Ma'am, you are before the court on a misdemeanor complaint or citation that alleges that on or about April 18, 2025, at the location of Twin Lakes Drive in Pittsfield Township, Washington County, State of Michigan, that you were in possession of drug paraphernalia. You understand the nature of that charge, ma'am?
Yes,
That's a misdemeanor punishable by up to 90 days, $500 fine plus court costs. Do you understand that?
yes,
All right. So first question I'll ask you, ma'am, is do you want to be represented by an attorney?
yes.
It's a public defender case, please.
Good afternoon, Assistant Public Defender Lauren Penny on behalf of Ms. Beavers. We waive further reading, statement to the charges and request another pretrial date, please, Your Honor.
Defendant able to waive formal reading. Standing mute, court will enter a not guilty plea. Pretrial in this matter will be adjourned to June 4th, 2025, 9 a.m. Bond in this case will be set in the amount of a $10,000 personal recognizance bond. I'll order standard conditions, including no assaultive behavior or any possession of weapons. I will indicate that there's to be no possession or consumption of any alcohol, recreational marijuana, or any illegal drug. You understand all of that, ma'am?
Yes,
Ma'am, if I sent you over to test now, would you come back clean?
I have marijuana, Mrs.
Pardon?
No,
What would show up?
marijuana.
This is where honesty collides with consequence. Tasha Beavers answers truthfully, but that honesty triggers immediate action. No medical card. Admission on record. Result: weekly random drug testing and immediate testing ordered. From a legal standpoint, the judge has no choice. Once drug use is acknowledged, bond conditions tighten automatically. This isn't punishment, it's supervision. But from a human standpoint, this is pressure. Weekly testing affects work schedules, transportation, finances, and stress levels. One sentence changed the rhythm of her life. Audience question: should honesty in court ever reduce consequences? Or does truth simply activate enforcement? This moment shows how courtroom dialogue isn't casual conversation. Every answer has weight. Every word moves the process forward, sometimes faster than expected.
Do you have a medical marijuana card?
No,
Is that the only thing that would show up?
in my medicine.
I'm gonna order drug of choice in this case as well.
Marijuana.
I'm gonna order 1 time per week random testing at community corrections. I want the defendant to test today. All right, thank you. We'll see you on the 4th. Court does call the case of the people versus Kia Berry.
Conrad Solar on behalf of Pittsburgh Township.
Public Defender Annalie Burgess on behalf of Ms. Berry. Ma'am, can you please state your name for the record?
My name is Kia Berry.
All right.
So Your Honor, Ms. Berry is scheduled to retake her test again this coming Friday.
Which part? The written or the
It
driving?
might be the road or the written test. Is that correct? Ms.
Okay.
Berry?
Yes.
Okay.
I'm very hopeful, as is she, that she'll pass. We're asking for an adjournment so that she can take that test.
What's this, May 12th? All right, I'll adjourn this. I finally saw one. Hang on, I'm correcting. I'll adjourn this. June 18th, 2025, 9 a.m.
So June 18th, is that right?
Pardon?
June 18th at 9 a.m., right?
Yes, ma'am.
Okay. Thank you so much.
All right, thank you.
Thank
Ms.
you.
Berry.
Thank you.
Court calls the case, people versus Daniel Bowe.
Conrad Solar on behalf of
This
Pittsburgh
one. Yeah.
Assistant Public Defender Natalie Pate and on behalf of Mr. Bowe, who stands to my right, please state your name for the record, sir.
Daniel Robert Bowe.
Thank you.
Thank you, Your Honor. So actually, Mr. Bowe is going to be accepting the offer extended today of double parking, but he did want to appear to speak with Your Honor as well.
Your Honor, he does have a temporary instructional permit, so I'm gonna move that count 2 of double parking. Accept that admission and move dismiss the original charge.
All right.
I was just wondering if,
Hold on, let me do this
all right.
part. Now, I'll hear from you, okay? Hold on. Just hold on a minute. Yeah, I can get to that. Mr. Bowe, do you admit responsibility to the fact that on July 12th, 2024, at the location of Carpenter Road in Pittsfield Township, Washington County, State of Michigan, that you did double park a motor vehicle?
yes, sir.
All right, court will accept that admission to count 2. Count 1 is dismissed. All right, what do you want to tell me?
Only thing I was asking is there any way I can get my fines and costs waived? Because I had to pay $3,400 to get my license back, and I'm about flat broke.
This is one of the most human moments in the entire docket. Daniel Bowe lays out his situation: prison time, family responsibility, massive back payments. And you can feel the courtroom lean in. Judge Simpson doesn't accept the story blindly. He challenges it, pushes back, tests credibility. And that's exactly what judges are supposed to do. What follows is rare: humor, skepticism, and empathy wrapped together. The judge calls out the narrative, then still grants relief. Audience question: should hardship ever erase fines, or should accountability remain absolute? This is discretion in action, not generosity, judgment.
I literally just paid, I think it was $3,450. I paid a little over $3,400 to get my license.
For what?
Huh?
Tickets and stuff?
Well, I was in prison during COVID, and my sister got a ticket in Livonia in my vehicle, and they didn't pull her over, but they issued the ticket to my plate, and it lapsed, and it turned into like over $3,000 in tickets. I ended up having to pay them. So
Not from one ticket, but
no, it was because my car wasn't registered while I was in prison, and she drove it. So it got hit with no registration, no invalid
so now
plate.
he's here blaming his sister.
Well, no, I mean,
you see what happened?
I still paid it.
You know what? You see what he's doing?
I still
He
paid
came in, he
it,
said,
but-
"Yeah, I want to go before the judge because I'm gonna blame her." 'Cause- How long did you do, young man?
I did about 3.5 years. Oh, sorry.
He also has a new baby at home.
Yeah, I got a 6-month-old.
I don't care. No, I'm kidding. No, I'm kidding. Is that your first?
No, he's my second. I got a 14-year-old who goes to Franklin High School in Livonia, so it's
You waited a
it's a
while.
challenge right now. Yeah, I got two different worlds going on.
Little boy or little girl?
Little boy.
And the older one is,
Oh boy.
so you got boys.
Yeah.
Okay.
I wanted a girl, but
Mm.
and once the boy came, I was
No,
happy.
you want a little girl, then they become teenagers and
Yeah, I know. I got a buddy that has nothing but girls and they're all teenagers now. Looks like he lost all his hair in the process, so.
wow. That's what happened. And you're gonna stay on the right course if I do something for you here on this?
Yes, sir.
Sure.
Absolutely.
So let's see. You told me you had a baby, right? Trying to get sympathy. And he said, none of this is my fault. It's my sister. Trying to say, oh, poor guy. Then I'm flat broke because I paid these other people $3,400, but I don't want to pay you, Judge Simpson, a dime.
Dang.
That's what I'm hearing, man.
When you put it out like that, it sounds way better.
I know. Didn't it though? Fines and costs of 180. I'll waive the entire balance. Good luck, young man.
Thank you, sir.
Thank you, Your Honor.
Thank you.
sir.
This is the payoff moment. After scrutiny, after skepticism, Judge Simpson exercises discretion. Entire balance waived. Why? Because the defendant showed up, explained himself, accepted responsibility, and convinced the court he would stay on track. This wasn't sympathy, it was persuasion. And it only worked because the judge believed future compliance was likely. Audience question: would you have made the same call as the judge? This ruling reminds us that courts are not machines. They're systems guided by human judgment, and credibility is currency.
Court calls the case People versus Annalie Burgess.
Conrad Silver on behalf of the township.
Assistant Public Defender Natalie Pate with on behalf of Ms. Burgess, who should be appearing via Zoom.
Yes, she's there.
Please state your name to the record.
Annalie Burgess.
Thank you, Your Honor. We're respectfully requesting an adjournment. Ms. Burgess has a DMV appointment out in Rhode Island, where she has family, where I believe her license originates from, on the 11th of June. So we would be asking for an adjournment after that date.
Will she be back by the 18th if she goes out?
Yes.
Yes.
You will? Okay. I'll adjourn you to June 18th, 2025, 9 a.m. All
Thank you,
right?
Judge.
Thank
You're
you.
welcome. Court does call the case People versus Diamond Buyers.
Conrad Silver on behalf of the township.
Good afternoon. Assistant Public Defender Lauren Kearney on behalf of Ms. Byers. Ms. Byers, please state your name for the record.
Diamond Buyers.
Okay, there she is.
Your Honor, we are requesting an adjournment so Ms. Byers can consider her options further.
Adjourn the matter June 18th, 2025, 9 a.m. On continue. All right. Thank you, Ms. Byers.
Thank you.
Court calls the case People versus D'Amico Cummings.
Conrad Silver on behalf of the township.
Good afternoon, Assistant Public Defender Lauren Kearney on behalf of Mr. Cummings. Well, Your Honor, I don't have an explanation for his failure to appear. I did him multiple times this week regarding this case. I did provide him with new information and the time. I don't have an explanation for his failure to appear. Request an adjournment for the record.
Bench warrant, 5,000. 10%. That warrant will issue immediately. Court calls the cases of the People versus Derek Embry.
Conrad Silver on behalf of the township.
Good afternoon, Assistant Public Defender Lauren Kearney on behalf of Mr. Embry. Mr. Embry, please state your name for the record.
Derek
Okay.
Embry.
All right, he's sideways, but that's all right. Now he's upside down. You don't know what you're doing, do you?
I'm on my phone. I'm on my break right now.
It's all right. Oh, now you're good. No, I don't know. All right, what are we doing? Because he's making me dizzy.
Unlike the previous case, Mr. Embry and I have not had a conversation. However, he is here. So I'm asking for an adjournment. There has been an offer made on this case. I think we're going to be able to resolve it. Just need a little bit more time.
All right. I'll adjourn it June 18, 2025, 9 a.m. All right, thank you, Mr. Embry.
Thank you. Have a good one.
Court calls the case of the people versus Michael Ericson.
Conrad Silver on behalf of the township.
Good afternoon, Mr. Public Defender Lauren Perry on behalf of Mr. Ericson. Your Honor, there has been an offer to double parking in this case. He has given me permission to accept that offer on his behalf.
So Your Honor, I move to add count 2 of double parking. You accept the admission, move to dismiss the original charge.
And you have authority to do so, and you do accept so on behalf of your client.
That's correct. Yes.
Court will accept the admission to count 2. Count 1 is dismissed. Fines and costs of $180. When can he pay?
He's asking for 30 days. He is inpatient at Don Farm right now. But he said he can get it paid in 30 days.
July 31st, 2025. All right. Time to get it done. Court does call the case of the people versus Angel Ford.
Conrad Silver on behalf of the
Court calls the case people versus William Katke.
Conrad Silver on behalf of the township.
Good afternoon, Assistant Public Defender Lauren Perny on behalf of Mr. Katke. Mr. Katke, please state your name for the record.
William Katke.
Your Honor, we have come to a resolution. Mr. Katke is going to be pleading guilty to allowing an ineligible driver to operate a motor vehicle, 257.326. I do have an advice of rights form that he gave me permission. Never mind, I don't even need this. Mr. Schiller informed me that he's going to give you an even better offer, Mr. Katke. He's offering you to admit responsibility of double parking, which is not, it's a civil infraction, doesn't go on your driving record, doesn't go on your criminal record. It's a fine of $180.
I'm good with that.
Okay.
I did.
My choice. Later on, I move that count 2 of double parking. If you accept that, move to dismiss the original charge.
All right, Mr. Katke, do you admit responsibility to the fact that on February 10th, 2025, location of Michigan Avenue in Pittsfield Township, Washtenaw County, State of Michigan, that you double parked a motor vehicle?
I do.
All right. Court will accept that admission to count 2. Count 1 is dismissed. Fines and costs of $180. When can you get that paid, sir?
Today.
Oh, thank you. Pay that today. May want to wait till later in the afternoon to try to, if you pay it online.
Yes, sir.
Okay. All right. Thank you, sir.
Thank you.
Court calls the case people versus Jaden Kendrick.
Conrad Silver on behalf of the township.
Assistant Public Defender Natalie Pate. Oh, he is here in Zoom. With on behalf of Mr. Kendrick, who appears via Zoom, sir, can you please state your name for the record?
Jaden Kendrick.
Thank you, Your Honor. I do not have a good phone number for Mr. Kendrick. I do have an email address, however, so I would ask first for an adjournment, and then secondarily, if Mr. Kendrick would be so kind as to call the public defender's office to update his phone number.
I'll adjourn him June 18, 2025, 9 a.m. Okay. You got the PD's number?
Oh, which Washtenaws?
Yeah.
I can get it.
Okay. You got to call them, make sure they have a good phone number for you.
Got it.
Okay. All right.
And this is by June 18th?
Yes, the 18th.
Thank you, Your Honor.
All right. Court calls the case, people versus Daniel Pearson.
Conrad Silver on behalf of this.
Good afternoon, Assistant Public Defender Lauren Perny on behalf of Mr. Pearson.
You need to unmute and turn on your camera. Oh, there he is. Okay, we got a picture of him. Now I need you to unmute.
Okay.
Got
Hello?
it? Okay. State your name, sir.
Daniel Pearson.
Even though he's up there with that Alabama hat on. I don't know. You know, this is Big Ten country. We might need to do something there. There we go.
Well, Your Honor, I'll pass along the message. Mr. Pearson his license has been medically revoked. He has gotten the medication necessary from his doctor to go back to the Secretary of State to, I think some circumstances have changed, to ask for his license back. So he's just waiting for a date from Secretary of State, and we're asking for an adjournment so he can complete that process.
Okay. But we don't have any idea how long that
No,
When-
I got the paperwork here. I'm sorry, I faxed it to him, and I'm just waiting on the appointment that my doctor filled out, that it was okay, that it was okay to reinstate my license, and I'm waiting on.
Okay, here's what I'll do. I'll adjourn it out to July 2nd, 2025, 9 a.m. Okay?
This moment blends procedure with personality. Medical revocation cases are slow, bureaucratic, and frustrating, and the court knows it. Judge Simpson gives time, but not endlessly. A firm date, clear expectation, and yes, a little humor about sports loyalties to keep things human. Audience question, does humor belong in court, or does it risk undermining seriousness? Here, it works. It lowers tension without lowering standards.
Okay,
And
thank you.
hopefully, what that will do is that will give enough time for them to give you your appointment, tell you what you need to do, and for you to buy a University of Maryland hat.
Oh, no, I don't know about that.
All right, Mr. Pearson, you take
All right.
care.
Thank you, I appreciate it.
Case of the People versus Zachary Styber.
Conrad Silver on behalf of Pittsfield Township.
Assistant Public Defender Annalie Burgess on behalf of Mr. Styber, who I believe is present via Zoom. Sir, can you please unmute and state your name for the court?
My name is Zachary Styber. Hello, Your Honor.
Hello, sir.
Thank you, Your Honor. I have had the opportunity to speak about this with my client. He is actively working with someone, and he has sent me some documentation to that end to try to get an administrative hearing date in front of the Secretary of State. We're asking for an adjournment to see if that is able to happen, and also there's some documentation I'd like to provide to Mr. Stiller.
All right. I will adjourn the matter July 2nd, 2025, 9 a.m.
Thank you, Your Honor.
All right, thank you. Thank you, sir.
Thank you.
Court does call the case of the People versus Stephen Trent.
Conrad Silver on behalf of Township.
Good afternoon, Assistant Public Defender Lauren Kearney on behalf of Mr. Trent. Mr. Trent, please state your name for the record.
Stephen James Trent.
Oh, there he is.
Your Honor, we are requesting an adjournment of the pretrial. Mr. Trent is working on getting his license. He has sent his packet to the revocation board and is waiting on a date.
Oh, okay, I see. July 2nd, 2025, 9 a.m. All right,
Okay.
thank you, sir.
Thank you. Have a good day.
Take care.
What we just witnessed wasn't one case, it was the system in motion. From dismissed counts and negotiated pleas to bench warrants, bond conditions, and waived fines, this docket shows how much hinges on preparation, presence, and honesty. Judge Simpson's courtroom operates on a simple principle: respect the process, and the process can work for you. Ignore it, and consequences escalate fast. Some defendants walked away relieved, others left with warrants, testing orders, or looming deadlines. But every outcome followed the same rules, and that's the real takeaway. Justice isn't random, it's responsive. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.